It is 10 a.m. I'm calling this meeting of Board of Elections to order in the absence of the chair. If the clerk could call the roll.
Thank you, Vice Chair. Chairwoman Medeiros, Vice Chairman Erickson.
Here.
Commissioner Pierce.
Here.
Commissioner Ramos.
Here.
Commissioner Scholes.
Here.
Commissioner West. Executive Director Robert Rapoza.
Here.
Legal Counsel Raymond Carcio.
Present.
Thank you, Vice Chair.
The one item on the agenda for today is that the board may vote to conduct a hearing on an emergency basis pursuant to General Laws 4246-6C to hear the appeal of Russell Jennings from a decision by the Boroughville Board of Canvassers rejecting his declaration for office for State Representative in District 47. As a preliminary matter, I would note that there was a hearing before the Board of Canvassers on 6/29 at 10:30 a.m. and later that day, although I don't have the exact time, the Board of Canvassers informed by email the Board of Elections that the declaration had been voided. Is that correct?
That is correct.
And then at 3:12, at 10:02 a.m. yesterday morning, an appeal was filed by Mr. Jennings, and we filed notice of this emergency meeting at 3:12 p.m. yesterday, once we determined that a quorum was available on an emergency basis. Counsel, could you provide a basis on the record for having a meeting with an emergency notice?
Yes, first you should take a vote to determine that an emergency meeting is appropriate, so that should be your first vote for this morning. This is governed by 42466C, and that is the provision under the Open Meetings Act that deals with emergency matters. This, if you find, may qualify for an emergency matter since those people who were recognized for their declaration papers have received those papers, petition papers at this point, so they can obtain the necessary signatures. So every day that you do not make a decision, assuming that the petitioner prevails, that's an assumption at this point, that petitioner would have fewer days than the other people who are running for that same office. In the past, even our Supreme Court, when dealing with matters, particularly with petitions, signatures, they've likewise heard these type of cases on an expedited basis. So it would be, in my opinion, appropriate to find that this would be eligible for a hearing in less than 48 hours, especially since it is publicly noticed. The parties of interest have been given notice as well, and for those reasons we should, in my opinion, proceed.
I would move that we conduct an emergency meeting.
Pursuant to 42466C. Is there a second? Motion has been made and seconded that we conduct an emergency meeting pursuant to the Open Meetings Law, given the nature of the matter before us.
And then, Mr. Vice Chair, if I could also note that typically, especially under the regulations that we've just promulgated, the local board would provide us with a full record of what it's done. Because this has been done on an expedited basis, we don't have that. You have just referenced the relevant times and dates, but we should submit that as an exhibit.
Yes, I was going to get to that right after the vote. So, all those in favor of the motion say aye.
Aye.
Opposed, nay. The ayes have it. So now I think we should introduce the material that's been presented to the board at this point as full exhibits. And then I'll get to recognizing individuals who may wish to participate in the hearing. I think the first Exhibit 1 should be the declaration of candidacy, including both the original declaration received by the Board of Canvassers in Boroughville by mail, as well as the electronic amendment to it that was sent.
I recommend that you view those separately in the event that one of the parties has an objection to any of these exhibits.
So pending full introduction, declaration of candidacy as mailed will be Exhibit 1, and the declaration of candidacy amendment as emailed will be number 2, pending entry as a full exhibit. In addition, we have a letter received by the Board of Elections July 2nd, 10:02 a.m., which is the letter from Russ Jennings, indicated that he wished to appeal to the Board of Elections the denial of his declaration of candidacy. That would be 3 pending full admission of the exhibit. Are there any other documents that we should mark as exhibits pending full entry?
Yes, I believe that also part of the packet is a reference. It appears to be the minutes. These are probably draft minutes that begins with emergency meeting of the Boroughville Board of Canvassers.
Okay. And
I recommend that be Exhibit 4.
Okay.
And then there is a letter which appears to be of even date. This is from the town clerk to the executive director. I recommend that be Exhibit 5. It's the one from Ms. Fenoff to Mr. Rapoza, June 29, 2018, Town of Boroughville.
So number 4 is the document that looks like this. That's the minutes. And number 5 is the one written on town stationery, which was received via email. Right.
Get the extra copy of that letter from the bank.
I think I just read this package apart. So there should be 5 marked exhibits.
The last one's number 1.
5th one is the letter from the town of Boroughville to our executive director.
Dated June 29.
Yes. All right, we have 5 pending documents before us. I think at this point I'd like to identify anybody in the audience who's interested in this, if there are any attorneys present who wish to file an entry on behalf of any individual, or if any individual is testifying on their behalf. So if you are interested in this matter, could you please stand and tell us your name?
I'm Russell Jennings. I'm the petitioner.
All right. Since this is going to be a recorded hearing with cert to the Supreme Court, we're going to be taking making a factual record, so you'll be under oath. So if you raise your right hand, please. Do you solemnly swear the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do swear.
You may be seated.
Thank you.
Is there anybody else? Yes.
Mr. Chairman, I'm William Lynch. I'm here today representing the Rhode Island Democratic State Committee.
All right. Do you have an entry?
I'll be happy to enter one. I don't know if you have a form, so I can do that.
And the party's assertion of standing is what?
Affected as anybody else would be with respect to what happens. And also, I can enter my appearance for individuals in the district. I'm happy to do that.
Could you get to the mic, Counsel? Just.
In addition, I'm happy to represent that I will enter my appearance for an individual in the district if there's an issue about jurisdiction or standing. And I have the name and address. I did not have that person come because, frankly, it's a holiday of the day before.
It's a Rhode Island holiday.
Correct.
The board has always had a liberal view of standing, consistent with the Gelch decision from the Supreme Court. Whether in this case, so this would not just be for the party, this would also be for an individual member of the public, a citizen of
In that
Rhode.
district. And I have the name and address that I can give you. I did not have that person come. She was present at the local board meeting.
She was actually at the hearing?
Yes.
Okay, I think that would be appropriate.
Yes.
Is that part of the record for the local board?
Yes.
Because we could obtain it that as well.
Yeah.
So it's for the same person who you appear for on behalf at the local hearing?
Yes.
We are attempting to regularize more of the process here, and part of that is the new appellate regulations request an entry of appearance. So if you could arrange to have an entry of appearance filed.
I'll be happy to write one out. I didn't know.
That's fine.
I didn't want to presume that the board had a form like they would in court or something.
We're still working on that.
Okay, I'll just handwrite one if that's all right.
That's fine, and I think that what Mr. Lynch just specified would be consistent with the Gelch standard.
Right. Right. As counsel, you don't have to be sworn in. So, all right. So we now have the parties that are before us. We have the exhibits marked. I'm sorry, go ahead.
Good morning, I'm Louise Feniff. I am the town clerk in Bartleville. And I don't intend to address you today, but if you have any questions for me, I wanted to be here for that purpose.
All right, if we need to hear your testimony, we'll swear you in at that time.
Certainly,
Okay,
thank you.
thanks. All right. Counsel, could you provide a brief summary of the matter that's before us, based on your understanding of it, and then we can ask
I
questions?
don't have anything to add beyond what you have already summarized for the public, which is the review of the declaration, the purported amended declaration, and then the hearing that occurred before the local board with the decision.
Right. Then I think we would proceed right to testimony from the affected individual who has already been sworn in. Mr. Jennings, is there anything you wish to add besides what's in your letter?
Only that I was away on business during the filing period, and had I been able to file in person as I wish, I would have corrected the error immediately. The town clerk would have told me in person, and I would have been able to fill out new documents. It is only due to the fact that I was away and that only original documents are allowed that created the problem. I've made every good faith effort to fill out the form accurately and within the deadlines. And all I'm asking for is the opportunity to gather the signatures and see if I can move forward.
Anything else?
No, thank you.
Right. Any questions from members of the board for Mr. Jennings?
Did you ever submit the original supplemental document?
Yes, that is included in the packet that I gave.
But the original, I mean, unless I'm mistaken, the second one was actually electronically transmitted?
Yes, but that, I brought that with me on Monday when I filed the appeal. And that was submitted to this office when I filed the appeal. I do have that copy.
So the original was never submitted to the local canvassing authority?
Correct, because I didn't get back until Monday, in which case all this had been decided at that point. I sent this, when I spoke to the town clerk, she stated she didn't think it would matter if the original arrived after the deadline or not, so she asked that I send an email version in.
So you were not present at the hearing with the Board of Canvassers?
That's correct. I've been out of town until Sunday.
And I just want to put on the record, by the way, that we do have a tape of the Boroughville Board of Canvassers, and all of that over there is designed to be able to play the tape if we so wish. I understand it runs for about 30 minutes. So, right.
Mr. Vice Chair, I have one question for the canvassing authority, if I may, for the town clerk.
Sorry, if you could step forward. No, sorry, we're going to have to swear you in at this one.
Don't be sorry.
Raise your right hand. Well, some people are. Raise your right hand. Do you solemnly swear the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Are you seated? State your name, please.
My name is Louise R. Faniff.
If the light is red, you're on.
You only need one.
There's
You
his
only need
green.
one, the other one.
This one's off.
That one on your left hand is up.
Right, got it. P-H-A-N-E-U-F.
All right. Counsel?
Yes,
please.
Ms. Fanoff, just with respect to the initial declaration of candidacy that was submitted, there is the reference to District 43.
Yes.
How many districts are there, representative districts for this community? Yes.
2, 47 and 48.
And when a declaration is accepted, what does the local authority do with it? Does it file it with the Secretary of State? Does it keep it, or?
My clerk handles most of it, but I believe that it's immediately put into the statewide database, and we fax it to, I think we still fax it, we may email it, to the other communities that are affected, and they're kept until they are complete, and then they're forwarded to the Secretary of State.
And outside of the incorrect district being listed, were there any other errors or incorrect information with this particular declaration of candidacy to your knowledge?
There were not.
Was there anything, any finding of any kind of misconduct?
There was not.
And you did receive the supplemental via electronic communication with the correct district that he seeks to run for?
That's right.
And that has been stamped as well?
That's right. And there's a timestamp at the top as well, showing that it was received before 4 on Wednesday of last week.
Have you ever been involved in the process where in the past a candidate has submitted a declaration that it was either incomplete or in any other way needed to be corrected before it was accepted by the canvassing authority?
Yes.
And typically, can you share with the board how that would be done? Would you notify or inform the person of the error or incomplete information?
Yes, and I think Mr. Jennings stated it pretty clearly. Generally, if someone comes in personally and hands us papers, we review them. If there's an error, and there are frequently errors, but if we review the papers, and if we notice an error, the most common one is an error in the way a person may put their name. We will ask them to correct that. People will generally do that. If the candidate is not present, their representative may take the paper to them and point out the error and have it corrected. In this case, we noticed immediately, of course, that the rep district was incorrect, and we knew that Mr. Jennings was probably out of town because we received it on priority mail. So I had my clerk call Mr. Jennings immediately.
And in the event that any person was present, provided you with incomplete information or incorrect information, and they corrected it in your presence, would the canvassing authority require it to be witnessed again, or would it accept the declaration that was originally submitted?
If the intended candidate made the correction in front of us, we would not expect it to be witnessed again. We would accept that.
Thank you.
You're welcome.
Any questions by the members of the board of the clerk? Thank you.
You're welcome.
Chairman, I have a question to ask of Mr. Jennings.
All right.
Can you give us an explanation how you came about putting the rep district number on your original application?
I believe I mistyped my zip code when I was using the online tool, but I was at a public library in Maryland, so I didn't take a screenshot or anything. I just entered, I used the Secretary of State.ri.gov website to figure out my voting district. I typed in my name and address, and it told me District 43. I had no reason to second guess that or double check, but in retrospect, something must have gone wrong. I'm willing to accept that I made a mistake, and I did every effort to correct that mistake within the deadline.
So was it your intent to put down the correct number?
It was my intent to put down the district that I lived in and was eligible for, as told to me by the Secretary of State website, yes.
And you put down 43 instead?
I put down 43, which is what the screen showed.
Right. Where is District 43?
Johnston, I believe.
Okay. Counsel, you've entered on behalf of an individual who's interested in this matter. Do you have any questions for Mr. Jennings?
No, sir.
All right. You may be seated. At this point, without board objection, we'll hear from counsel.
So, Your Honor, members of the board and your esteemed legal counsel, I'm here actually to say that the board got it right. You know, we are, particularly as we approach July 4th, a nation of laws and a state of laws, and our legislature has very clearly set forth the legal requirements in order to declare your candidacy for office in the state of Rhode Island, including for this particular issue, for this particular office. And I would point out, as I'm sure the board already knows, some of what I'm going to suggest to the board is you're obviously already aware of, but under 1714-1, which is the law that we're required to follow, and that's for everybody. You know, this, respectfully, and I see this board as a judicial body, it's not permitted to pick and choose who has to adhere to the law and who doesn't. I don't know Mr. Jennings, he seems like a very nice person, but the law nevertheless applies to him as it does to, I presume, hundreds of other individuals who have declared for office all over the state during this particular filing period. I don't think it's permitted by law, nor can it possibly be expected that the state of Rhode Island, through its local board of canvassers or this esteemed body, can be, nor are you legally permitted to unilaterally sort of pick and choose individual declarations and make corrections as may be requested. The declaration form which the Secretary of State has devised and which is required to be used, and by the way to be submitted in its original form as signed by candidates, very specifically tracks the statute that I just cited to you. And the form requires, point by point, each and every requirement that the statute sets forth, obviously starting with your name on the voting list, etc. And I would respectfully suggest that the statute, as your legal counsel can possibly opine when I'm finished, it's a strict statute and it's mandatory, and it says that the declaration of candidacy shall include the following information. So it's not that there's a lot of leeway here and it says you may include, and I don't want to sound like a lawyer because I know that turns everybody off right out of the box, but I would respectfully suggest that shall is a very strict construction and requires that anybody who filing declaration of candidacy absolutely must include certain information. And one of those requirements, very specifically, in fact it's 17-14-1, number 4, requires that the office sought has to be stated on the declaration. In this particular case, Mr. Jennings did declare for office. He declared that he was going to be a candidate, or wanted to be a candidate for representative in General Assembly, District 43. So he declared his candidacy without question. I'm not here to dispute that. But he didn't declare for what he now says is the district that he wants to run in, and that's just simply not permissible. Any more than it would be permissible if he declared that he wanted to be a candidate for senatorial district and then came in here and said to you, I meant representative district, or I filled in representative district 47, but I really wanted to run, I meant to run for attorney general or lieutenant governor. This is a legal form. It mimics the legal statute that we're required to operate under. And it clearly references District 43. And I'm going to try to be short, but I'm going to mention just a couple of other things that I think are important for the board to consider. One is the email, the corrected email is, respectfully, I don't think can be considered. It's not under the statute. If our legislature wants to go back in and amend the statute to permit email filing in this day and age, certainly they're entitled to do that. Maybe Mr. Rapoza can talk to them about that, I don't know. But at this point in time, that's not a consideration and not permissible, number one. Number two, I don't fault Mr. Jennings for being away on business. In fact, I congratulate him. I don't know what his business is. But to submit that if he had been here and walked it in, the clerk would have corrected it. She probably would have, because they're very good up there, as most of the boards of canvassers are. But he didn't. He didn't. He mailed it in. And by the way, I don't contest that. There were some who said, well, you can't mail them in. I think you can mail them in as long as they're received before 4 p.m. on the deadline date, and Mr. Jennings did that. And so the onus was on him, frankly, as it is on, I don't know the number, but as it is, I presume, on hundreds and hundreds of other individuals who file these declarations, to do it properly and to comport themselves with the law. It's not, you know, a smorgasbord or a cafeteria where you can pick and choose which of these items you want to comply with. You're mandatorily required to comply with each and every one of them, and he didn't do that. So, you know, I would respectfully tell you that in this particular instance, the board of canvassers, who spent a considerable amount of time reviewing this matter, did get it right. You know, this is not a case, by the way, and I'll just point out that, as the board probably knows, many of these cases in the past, and many of you, some of you board members were still here when I was here more regularly years ago, but many of these cases deal with the issue of signatures. And in fact, the legislature saw that issue, and our legislature addressed that issue in this particular statute, because there were many issues where people were signing and leaving out a middle initial or signing differently than on the voter list. And our legislature considered that and amended this statute, as I'm sure you know, to make it much easier for people to declare with a different signature that might appear on the voter list.
That's the Sunland case.
That's right.
I was the one that found the flaw in the declaration of candidacy.
That's right. I'm old enough to remember that.
Okay.
But my point in this particular case is that the legislature also could have further amended this statute to change or modify any of the other mandatory requirements, like it did with signatures. And it could have made, had it wanted to, it could have given this board and the local board of canvassers leeway on some of these other issues, and it hasn't done that. So, you know, that's a function of the legislature. They pass the laws. As a lawyer, I try to see that they're enforced. And this law, it may seem unfair. Many times that happens. Your Honor, I was in front of you many, many times over the years, and the law is the law. And you used to remind me many instances when I argued differently that that wasn't the law, Mr. Lynch. So in this particular case, I think the law is the law. And I think that, frankly, it wasn't complied with. There doesn't need to be any intention. I'm not sitting here accusing Mr. Jennings of intentionally doing anything. There's no intent required. This is not a criminal situation. But on behalf of those in the district, he declared, but not for District 47. Consequently, the Board of Canvassers got it correct, and that was their finding. I'm happy to answer any questions or respond to any questions or issues that the board may have.
I have a couple of questions. Mr. Lynch, other than the office sought of the 10 items that are listed in that statute, are there any other errors?
I don't think so, Your Honor. You know, someone, it wasn't me actually, well, there was some discussion at the hearing with respect to the signatures of the witnesses, because they don't list their residence, and they're clearly illegible, but appear to be from people from out of state. So I don't frankly believe that that needs to be even reached or discussed, because I think that the declaration fails on the District 43 issue.
So the only objection you have is item number 4 under the statute.
Yes.
It says the office sought.
Yeah.
But the statute doesn't say it's a district. It just says office sought, so the office sought would be representative or senator or councilman. It doesn't say you know, the ward, district, or whatever. So it seems to be ambiguous, doesn't it?
Not to me. Frankly, I mean, if you're going to run for state rep and you're going to run District 47, the form clearly requires it. It's not left blank, by the way, so that Mr. Jennings can say, gee, I didn't realize, I just thought it was rep district, I didn't realize I had to fill that in. He typed in 43, and by the way, it's not handwritten, which was another point I made to the Board of Canvassers. It's not a case where it was handwritten and you can't really clearly tell if it's a 43 or 47. It's very neatly prepared and typed and references 43. So I respectfully tell you that clearly you have to indicate what district you're running in. And that would place, frankly, that would place these boards in the impossible position of having to somehow on their own sort out, you know, hundreds of declarations, each and every declaration period, and try to figure out what district they were in or what office they were seeking, which I don't think clearly is the intent of the legislature.
But the statute says the office sought, not the office and district if required. The form says the district number, but the statute
I agree. I have it. I agree. I have it right in front of me. I respectfully think that that requires you to list the office that you're seeking. You can't, at least as of today, you can't run in Rhode Island for state rep
you have to run for a district, right? There's no general office that you can run for.
And in this case, there are actually 2 districts that are affected. This
Right.
might, if one were to leave the district blank and there was only 1 district that could be affected, then there could be only one conclusion as to what office that person sought. Here it seems that we have districts 47 and 48 that are affected by this declaration. Now, whether you think that's dispositive or not, I just wanted to point out that that's why I did ask the town clerk how many districts were possible to be designated here. There's more than 1.
But the only district that he would be qualified to run for would be the district in which he resided.
That's right.
The statute requires that a person be a voter in the district for the office that they seek.
Yes, and
That's not always the case. In some locations, you can run for Congress outside of your residence and you can run for different. But in this case, our statute makes it clear you have to be a resident of the district that you seek to represent. With respect to the, I just want to go, I have to go back to the Sunlight case for a moment because I think that was 1988 is my recollection, between 1988 and 1991.
Seems like yesterday.
It just seems like yesterday. But the statute at that point under section 1714.1 said that the declaration shall be signed by the candidate as his or her name appears on the voting list, and then period, and then the additional language beyond that was added. The additional language said the signature shall be accepted as valid if it can be reasonably identified by the name of the signature the voter purports to be, which brings it to the same standard we use for mail ballots and for other purposes. A variation of the voter's signature by the insertion or omission of identifying titles or by the substitution of initials for the first or middle names or both shall not in itself be grounds for invalidation of signature. That's actually the Sunland line, because he submitted his declaration as, I believe, B.G. Sunland, and he signed the voter list as Bruce G. Sunland. So there was an argument that could be made, and a strict interpretation of the statute at that time would have taken him off the ballot. But the predecessor board here allowed his candidacy to continue. I don't think it actually got to the board level. So clearly there was a movement toward making it more, to making declarations more accessible, to make them more, make it easier for people to declare and to reduce the number of technical errors that could disqualify a candidate. That was clearly the legislature's intent. And the other point I want to make is that we can argue from now until forever about what shall means, but I think the governor's legal counsel's position consistently for the last 4 governors has been when they say you shall appoint a candidate person to fill a judicial position within X number of days, they mean it's optional, not mandatory. So if we accepted the governor's...
That's not an argument I'm wading into this morning.
But if we
I'm not a candidate for any bench.
But if we accept any of the last 4 governors' legal counsel's analysis of that statute, they would say shall is not mandatory. So,
Judge?
yes.
I just, one of the things that just piqued my interest is I think when the council mentioned if you run for Senate and say you come in and say, no, I really meant to run for the legislature, what do you do in that case? I mean, if you made a mistake on the form, whether it's intentional or not, and you do say, and that's a prime example, that's what really made me think. I write down I'm going to run for the Senate, and then I come in and say, no, I don't mean the Senate, I mean legislation. What do you do? What do you do? Now, there'll be candidates that would, and suppose in the district there is no other candidate. So does one one district stay empty and the other one that you really want to run for, I don't know if that's legal or not, because maybe when your name came up in that district, someone who wanted to run might say, well, nah, not really. But because that person put his name in that district and then come in here and say, no, I don't want that district, what does it do for me who really wanted to run and didn't because I was worrying about the challenge? So, could you?
If I may, Mr. Chairman, the issue is a difficult one here because designating the district in which you want to run may, in this sense, be a convenience to the Board of Canvassers, since the person would only be eligible to run in the district in which he or she lived. So an argument could be made that the designation of the district in a way is to convenience the Board of Canvassers so that they know where this person is running. I set that aside. And balancing this, the importance of accuracy in the filing is also very important. I think what Dr. Pazner has talked about is an important issue, but I think there is a distinction there between if you say I'm running for representative, you're running for representative, and a change in office would be a significant difference from this about the issue of how important is the designation of the right district at the time of filing, in this case where there could only be one district in which the person could run.
I could, if I may, I can give a little more direction. This is not dispositive, but I did some research yesterday evening just to see if there are any cases directly on point. I could not find that any that were factually the same as this, but there was a Supreme Court case that came out in 1977 dealing with Chapter 14, a different part of Chapter 14. Lassite versus State Board of Elections, 376A second, 320. And in that case, it dealt with nomination papers and signatures that were submitted for the nomination. The affidavit that was presented to support the signatures indicated that he was present for each of those signatures that were submitted. In reality, this person, who is the son of the person running for office, was present for only 36 or 38 of those signatures, calling into question the balance of those needed.
That was the House 97 race involving June Vlacity, and the son was the son of the incumbent rep. Right?
It was the son, yes.
Yeah, I did that case too.
Okay. This, and you may have a different memory of what's in the decision. This what occurred is that before the deadline for submitting the signatures, the candidate came in with 5 additional affidavits to cure the incorrect affidavit that was originally submitted. And both this board as well as the Supreme Court found that those affidavits cured the original error.
Right.
Now there are a few distinctions between that and this. First of all, we're not dealing with signatures, we're dealing with the declaration. The other difference is that in that case, the person who submitted the offending affidavit did so intentionally. Now here we have no evidence to suggest that what occurred was intentional. To the contrary, it was an error. There's one other difference too, just to show that this is not a clean-cut application. In this case, the petitioner has submitted an electronic version of information as opposed to an original. So in Vlacite, 5 original affidavits were received. To make this more analogous, you'd have to have 5 affidavits coming in electronically or facsimile or copies. So at least in that case, they satisfy the requirement, which is consistent and which is under 17(1). There's a statute here, 17(1). 7.1, that all filings shall be original that go to the Secretary of State. So we have these competing statutes, we have the requirements, we have the decision by the Supreme Court that allowed the cure to occur. So frankly, since this has come before us since yesterday, I'm of the view that the board could justify either decision. There's enough case law or statute to support either side.
Could I just add one, since we're going to now sound like lawyers, there is another case that I did find, Felice versus Rhode Island Board of Elections, goes back to 1991, and that was a district court case reported at 781 Fed Sub 100, and I'll quote part of the court's decision in that case, and that again, like many of these cases, did deal with signatures. The declarant in that particular case, obviously her name was Felice, Denise R. Felice, and in that particular case, there was another case where she listed, she signed her declaration papers as Denise R. Felice, but her name on the voting records, the voting list was Denise Felice, in other words, no middle initial R. She sued this board, alleging that the board acted arbitrarily and capriciously by denying her equal protection to run on that issue. And in that particular case, the district court, federal court, held, and I'll quote, that this board did not deny Denise due process rights because they wanted to prevent confusion among voters, and here's the important part, I think, for this case, and expeditiously certifying candidates clearly outweighed the minimal burden imposed on Felice to get on the ballot. And that's at 781 Fed Sub page 103. That's the closest thing I could find to this case. And I don't want to be redundant, but Mr. Jennings, with all due respect to him, he did declare for an office sought, as is required in the statute. He declared for Representative in General Assembly District 43. He put that on the form. So it's not a case where it was left blank or he didn't put it on and he could come in and say, I declared for the office sought. I didn't realize I had to fill in and I thought that was just part of the form. He, by his own testimony, sworn testimony today, he put down 43. I'm not criticizing him for that, but that's the fact.
I have an objection.
Well, excuse me, that's the law. And I think that law is very clearly set forth in the Felice case as well.
I'm sorry, could you give me that site again?
781 Fed Sup 100, District Court, Rhode Island, 1991, and the quote that I read is on page 103.
Mr. Jennings, yes, go ahead. Mr. Jennings, do you have a concern?
Yes, my objection is I only ever intended to put my address in the district I intend to run for. There was never any intent to run for any other district. I would even go so far as to say, by comparing the statute to the form creates an undue burden on applicants to list their district when that is not statutorily required. If I had left the district blank, or if there was no district marking, it would be clear which district I intended to run for. I did choose the office that I wished to run for, and the fact that the form goes above and beyond the information required by the statute, I think makes that information of less importance than the fact that the form was filled out, selected the office, and submitted correctly within the deadline. If I had listed an address aside from the one I lived at, I would understand why people would be prone to be more strict, but I would like to point out this case is different in that the address and the district that I amended do match, and you did get, by the minimum statutory requirement, a valid declaration of candidacy before the deadline.
Mr. Chair? Yes.
I asked the legal counsel a question on right under section 17-14-1. Look at the subsection 4, talks the office sought. Do you like to opine on the meaning of that term?
Without doing any research to support that it would be difficult, it is something that's developing for this hearing. But the declaration does require that the office include the specific seat that is sought, not just the office. So in this case, District 47 or 48. I think that there is a problem when you have the designation of an office and you have more than one district that could be affected. So in my view, if there was only one district that could be here, and if that were blank or transposed, there would be no question as to what the office is. But when there's more than one district, then there is more than one office that could be part of the election. I don't know if that helps at all, but that's just the best I can offer at this point.
If I may, isn't it true, Counsel, that the petitioner here could only apply to run for one representative district?
That's correct.
There was no, for example, if it were city council and he could run at large or for a ward or something like that, but in this particular case, the only representative district that this person could declare for, properly declare for, was the one in which he resided.
Yes, I agree with that, and I think that the information that was sought by the canvassing authority, namely which district, since it wasn't 43, was necessary so that it could make the determination on the declaration.
See, I have a concern here, Mr. Chairman, that if the candidate applied for a representative but did not include the district number because then he did not know, does that mean that the declaration of candidacy is invalid? Because according to the statute, it's not, because it says it provides the office sought. He puts down representative. Not knowing what district he is, he can apply for a representative and at some point find out the number.
But that's my point. This declaration, without question, Mr. Jennings and I agree, clearly this declaration that he filed declares for Representative General Assembly District 43. It's not blank. He declared for District 43.
But what does the word office mean? Does it mean the seat or the office of representative or the office of representative of District 43?
I think
that's the issue.
Of course it is. And I think he signed under oath, as he's required to do, that he was declaring for Representative General Assembly District 43 and the signature's witness. I mean, that's what happened. I can't unring the bell.
I would like to just discuss the signature requirement because it seems to me that the legislature has taken steps both with respect to the declaration of candidacy and the signatures on nomination papers in order to broaden the capacity of people to run for office and to not eliminate their declarations on technical reasons. The case that you cited, the federal district court case, was decided under the, well, I'll call it the pre-Summerlin law, because the person involved, Felice, was a candidate for Democratic National Convention delegate in 1988.
Correct.
And it was a series of these cases where a person did not sign precisely. And they quote Malino and Cormali, both of which were decided in the 70s, where it was strictly interpreted that if you used initials or you didn't use a middle initial or you added a middle initial, if there was any variation whatsoever in any way, no matter how technical, between the signature on the voting record and the signature on the declaration,
or even if you couldn't read it clearly.
Right. If it was, so some of us had problems with our declarations. Myself included, but no, only in the sense that signatures can be very hard to read, right? And that's your point.
Yes.
The legislature made a similar set of changes with respect to signatures on nomination papers, so that, because one of the matters in the Velocity case involved the fact that some of the signatures were not identical, and that was an issue that was also before the board at that point. And once again, the board ruled that the signatures had to be identical, and the supplemental affidavits were filed, is my recollection of this case. And it seems to me that the legislature is telling us something about how we should treat technical defects. That's a conclusion that I think can be fairly drawn from those cases.
I would agree with you as it pertains to signatures.
You don't think that can be transferred to the broader interpretation of the election law in a way designed to encourage candidates to run for office?
Well, I don't know that I disagree with that, but the only thing I will say, and I feel like I'm starting to repeat myself, is that there is no ambiguity here. This is a declaration that was filed under oath for District 43. So, again, I said probably 15 minutes ago, if it was not legible what number was written in there, then I think the argument could be made that would be more similar to signatures. But there's absolutely no dispute amongst anybody on any side of this issue, but that is the number 43 that was.
But the testimony. Hold on, just one second. The testimony, though, is from the town. Is that if this person were present, and in that context, there would be a dialogue. The declarant would be able to just inform the town of the correct district, and no other information would be needed. They would not even be looking for another set of signatures for a new declaration. It would just be essentially cured from that verbal discussion. Here we have a facsimile, electronic, with new witnesses, with the correct data, all being provided before the deadline. Wouldn't that fall more into the camp of what Vlasite was trying to achieve versus what Malino had, which was back in 1970, requiring the strict compliance with the statute?
No, I would not agree with that. I heard the testimony, which, of course, this is not a court of law, but it's strictly hearsay. And number two, the board was represented here today in Burrillville, and I think everywhere would do a great job. So if you walk in with your papers, I think more likely than not, it's been my experience that the board will try to take a quick look at them, and if there's a mistake, they probably try to correct it, but they're not required to do that. There's no requirement that the board sit down and take these declaration papers and go through them to see if the district matches up with an address. They probably, I would imagine, do that as a courtesy, and I think in this case, that's exactly to the credit of the board in Burrillville. That's what they did, but that's not required. That's not in the law. You know, this is a case, whether we like it or not, you've got to apply the law. And I respectfully suggest that the law is clear, as is the declaration. And the email, unless the legislature wants to convene and you know, modify and amend the requirements with respect to original declarations, and they can do that. They could have done that anytime they wanted, including this year, next year, but that hasn't happened. So we can't sit here and say, pick and choose, you know, what we're going to do. This would open the door to, hundreds and hundreds of these every election cycle.
I don't think that's a likely possibility.
I would hope not, because mainly because the boards do such a good job of checking them.
Right.
But, you know, Mr. Jennings had every right to be away on business. I'm not criticizing him for that. But had he walked in, maybe there would have been a different result. But he didn't, and that's not nobody's fault.
But it did. His being away on business did make it a physical impossibility for him to correct the change in person.
But my only point is that I want to bend over backwards. I'm not criticizing him for being away on business, but if we're going to go down that road, you're going to have people come in here who are going to say, I was away at a family function, I couldn't be here for the 3 days. The legislature has set a limited, specific period of time to declare, and everybody who runs has to operate under those same rules. And you don't get to say, I'm not available this time, so I want to do it differently. It just doesn't work that way.
Right. Any other questions?
Well, Mr. Chairman, let me just say that my position on this matter is, I guess, influenced by my concern that people be encouraged to run for political office, and that for that I admire Mr. Jennings' efforts to qualify here. looking at the overall situation, first of all, the question of the designation of the district is really in many ways, it could be considered a convenience to the Board of Canvassers, since in this particular case there was no other district in which he would be qualified to run. Setting that aside, I look and I have concerns about accepting email as opposed to original filings, but that was a good faith effort on behalf of Mr. Jennings to correct his notice of intention to run. And I look that at the same way as perhaps what would have happened if he had been at the Board of Canvassers office when he filed his declaration. Putting all of those things into context, I would move that we reverse the opinion of the Board of Canvassers in respect to his eligibility to get papers to try and run.
So the motion is, there's been a motion made to reverse the decision of the Board of Canvassers and to instruct the Board of Canvassers to accept the declaration of candidacy and to issue nomination papers forthwith. Is there a second to that motion? Any further discussion on the motion? All right, all those in favor say aye. Aye. Opposed, nay. The ayes have it. And we will prepare an appropriate order, but the clerk is here to hear the decision of the board to issue the nomination papers. Being no other business before the board, is there a motion to adjourn?
So moved.
Second?
Thank you, Mr. Chairman.
All in favor say aye.
Take care.
The ayes have it.
Next time.
Good luck to you.
That's an interesting question.
Yeah, really.